Let's talk about the 5 secrets rich people use to protect their assets from lawsuits. And if you have more assets than the average bear, this video is for you, because today we're talking about a special kind of trust, one that many of the wealthiest people in the world use to legally protect their money from lawsuits, how it works, when to set it up, and exactly what happens when legal trouble starts knocking. So let's go ahead and dive in. I'm the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been in the asset protection business for 34 years, and I've been setting up Cook Islands Trusts for nearly 30 of those years. My team and I have built the largest asset protection firm in the country. In fact, we've established more Cook Islands Trusts than any other organization in the world. So if you're new here and if you're serious about protecting what you've built, click the subscribe button and hit the like so YouTube knows that this video is worth sharing. So let's go ahead and start with the why. According to the USA Today, Donald Trump and his companies were involved in over 3,500 lawsuits over 3 decades. And whether you love them or hate them, it's a clear demonstration of what happens when you have money, real estate, and notoriety. You're a target. And Trump isn't an outlier. According to attorney Jay Minton, the average person faces 7 lawsuits in their lifetime, and millionaires, they face an average of 11. And right now, there are 21.95 million millionaires in the U.S., and over 80% of them are self-made. And these aren't people living off grandma's trust fund. They've built their wealth from scratch. And that also means they have something to lose, everything to lose. So that's why asset protection isn't a luxury, it's a necessity. So what do the smart ones do? What do they do to protect themselves and shield their assets from the ravages of lawsuits? They don't just cross their fingers and hope insurance will cover everything. They don't just rely on domestic trust that some ambitious attorney can pierce like tissue paper. They use something called a Cook Islands Trust, and sometimes a Belize Trust or Nevis Trust. Cook Islands being in the South Pacific. It's a part of New Zealand. Belize it's the only English-speaking country in Central America, and Nevis down in the Caribbean. All great jurisdictions for trusts. Now, these trusts can do some pretty exciting things, and this isn't just theoretical. It's the gold standard how the rich stay rich when someone sues. I mean, lawsuits are the biggest wealth killer, and this is the strongest way to keep that from happening to you. So yes, domestic trusts exist, and we've set up many, but the U.S. judges are increasingly aggressive and many results-oriented, and they don't care about how airtight your paperwork. In fact, one of my attorney friends joked, you know the difference between God and a federal judge? And he said, well, God doesn't think he's a federal judge. In fact, I've studied the case law. Domestic asset protection trusts often fail when you study the actual results these trusts get in court. In fact, courts have ruled time and time again that if you're still in control of your assets, or if they're being controlled in the U.S., a judge can compel you or the trustee to hand them over. So that's why we turn to jurisdictions like the Cook Islands, again, like I say, south of Hawaii, Belize in Central America, and Nevis in the Caribbean, which is southeast of Florida. I've been there many times. These countries are not only beautiful, but they've built rock-solid legal systems that protect trust assets from foreign judgments. So here's how it works. First, we set up a Cook Islands Trust, and inside that trust, we place a Cook Islands LLC, or a Belize LLC, or a Nevis LLC for Belize, or a Nevis Trust. And you, the client, are the initial manager of that LLC. And what that means is you control the bank accounts. You sign on the accounts, you can move the money and so on. But here's the kicker. When a lawsuit strikes, your local court says turn over the money. You don't have to, because technically you no longer control the LLC. And the reason is our licensed bonded trustee company law firm steps in only when needed, and they're located offshore outside the U.S. court jurisdiction. So when your adversary goes to the judge, that judge has no authority over the trustee company, and the Cook Islands doesn't recognize court judgments. Most countries do recognize U.S. judgments, but Cook Islands is one of the few countries that doesn't. So that's the firewall. So let's make it simple. When the waters are calm and everything's cool, you're the manager, you're in control. when a lawsuit comes in, you can hand the keys temporarily to the offshore trustee company, somebody who's licensed, regulated, bonded, and has never taken a client's money in over 3 decades of us doing this. And the moment the threat passes, the control can go right back to you. So it's like having a bulletproof vault, but you get to keep the key unless the burglar breaks in, and then the vault locks itself and nobody around you can open it except for the security team stationed in a special location that looks out for your best interest. So the common question is, do I lose access to my funds if the trustee steps in? And the answer is not at all. You still request distributions. You can still do that. The trustee's job is to say no to the court, not to you. So their role is to follow the terms of the trust that you helped design. But unlike you, they can't be forced by a U.S. court to turn over a dime. They don't have to worry about contempt of court or jail time in your jurisdiction because they're simply outside of it. U.S. courts don't have jurisdiction over the whole wide world, only in the U.S. So they're safe and they're immune from U.S. court orders. Now keep in mind, we're talking about legal, moral, and ethical funds, and we only take clients that are doing ethical things and legal things. If somebody didn't want to pay their taxes, they're not going to be our client. If somebody wanted to rob a bank and put the money in a trust, and not only would we not take them on as clients, and our trustee company law firm wouldn't take them on either. So the banks wouldn't open up accounts for them. Once they see that nonsense that'll be online. So where's the money actually held? That's the next question. Where do we hold the money? So it doesn't have to be in the Cook Islands, though they offer great options. Very good bank that I actually use in my Cook Islands trust. Usually it's in Switzerland or Liechtenstein. Any top-tier private bank that offers confidentiality and strong financial controls. Countries that don't recognize U.S. judgments or don't acquiesce to them. So we often use Swiss banks. You get your own account number, your own relationship manager, have some of the best money managers in the world, and 24/7 online access, just like your Chase or Wells Fargo or Bank of America account, but a lot more private. Now the LLC is owned by the trust 100%, and the LLC owns your bank account. And because you're the manager initially of that LLC, until the bad thing happens, you have control. Now, you might be wondering, that's great for cash, but what about real estate? Now backing up a little bit, keep in mind that the only time this trustee would step in is when the courts would take your money. So would you rather have a 100% chance of the courts jumping in there and scooping your cash and taking it all and leaving your pockets dangling inside out and having to sleep under a bridge drinking wine out of a paper bag? Or would you rather have a licensed bonded trustee in the most highly regulated jurisdiction in the world, Cook Islands, for example, do what you paid them to do? And, trust our experience of doing this for almost 30 years. And the fact that I have one, I'm in the business, and I have a Cook Islands trust for myself. Our trustee company law firm is the only signatory on the account, just because I like to practice what I preach. I sleep like a baby. Okay, now I'm moving on to real estate, like we were just talking about. What do we do for that? U.S. real estate is subject to U.S. court jurisdiction. So we don't place it directly into the offshore trust because a judge could say, the real estate in an offshore trust, I'm going to take the real estate anyway. So instead, we use first land trust for privacy of ownership. So each property goes into its own land trust. And then a domestic LLC becomes the beneficiary of that land trust for a rental property. We don't involve an LLC if it's your personal residence, because that's a different tax category. So it's just a land trust only if it's your personal residence. And then we perform what's called equity stripping. Here's where the power lies. We perform equity stripping. That means we record mortgages against the properties, and these are liens that are initially payable to the offshore LLC that's inside the Cook Islands Trust. And then as a step number 2, if needed, we get a third-party lender to buy those mortgages. And the proceeds of those mortgages get wired into your offshore trust-controlled account. So even though your house or building or commercial property is in the U.S., the equity, that's safely offshore. So the question is, who uses this strategy? The plastic surgeon in Beverly Hills who was sued for $6 million. We protected his liquid assets offshore, stripped the equity from his medical building and his house before the plaintiff got it. A real estate investor in Texas who owned 12 rental properties, he used our trust structure to shield all of his equity before a major liability suit hit and ended up settling for pennies on the dollar. Even celebrities and billionaires use structures like this. We've worked with household names names, but due to confidentiality, naturally, let's just say some of them have been on the Forbes list, and some have been less financially well off but wanted protection. So here's a little known fact. Attorneys themselves are one of the biggest client groups that call us to have us set up these trusts for themselves. We've helped countless law firms protect their own money, and then they also will purchase the trust from us and turn around and charge their clients, up to $100,000 for similar structures that we were the ones that set up. Now, we charge far less because we set up, more of these than anybody else in the world. So here's the question. What can you do, or what should you do if you want to protect your assets like the wealthy do? First of all, don't wait. Asset protection is like insurance. If you try to buy it when your house is already on fire, it's too late. Courts can call last-minute transfers fraudulent conveyance and undo them. Now, they'll have a hard time undoing them if they're offshore, but they give you a lot more of a hard time if you do it, while your hair's on fire. So it's best to do it as early in the process as possible. So the best time to set up a trust is when you don't need it, before you need it. Now, we can also set it up, after you've been sued, but it's going to cost you more, and it's also you're going to get a lot more scrutiny by the courts. You can give us a call if you like to. It's up to you. If you're serious, not if you're just curious, but if you're real serious, call us at 954-400-1050. You can speak with one of our attorneys or consultants, or you can visit us at assetprotectionplanners.com for a lot more free information, and you can get a confidential consultation if you're really serious about this. So we'll walk you through exactly what structure makes the most sense based on your assets, based on your risk and your goals. So let's go ahead and recap. Rich people get sued way more often than average Americans. Insurance isn't enough. You can get sued for way more than your insurance covers. So many things that insurance doesn't cover, like breach of contract, divorce, something where they even falsely allege fraud, those kind of things. Insurance will cover that. And of course, you can get sued for way more than your insurance covers. We have people contacting us all the time that had $1 million of insurance but got sued for $5 million. So no matter how high your insurance is, you can always get sued for more. Insurance isn't enough, so courts can still go after your uncovered assets. Next, domestic trusts are vulnerable to U.S. court rulings. You get a results-oriented judge. We've seen it over and over again. They'll penetrate through a domestic trust like a hot knife through butter. Next, a Cook Islands trust with a Cook Islands LLC inside of it, or a Belize trust with a Belize LLC inside of it. If you're already in a lawsuit, that's probably where we'll go. These trusts gives you power when times are good and legal invincibility or near invincibility. We've never seen one penetrated when times are tough. Our licensed, bonded, trustee law firm only steps in when necessary, when the courts would take your money, and so that you can't force to comply with a U.S. court order. Real estate can be protected with land trust LLCs, and most powerfully, equity stripping. We combine all three for real estate, and we've helped tens of thousands of clients, I believe over 100,000 clients, mainly people with high net worths in the millions, legally shield their wealth. So if this sounds like something that you need, we're here to help. You can call the number I just gave you, visit the website at assetprotectionplanners.com. You can get a lot more free information there and protect what you've worked so hard to build. So if you found this video helpful, please like, subscribe if you haven't, so you don't miss out on any more insights like this one. So this is The Business Guy, protecting wealth, preserving legacies, and helping the spark stay safe. Thanks for watching.